If members would, including myself, make sure you're logged into the system. I hadn't either. I'd like to call the Public Service Subcommittee to order, and I'll be sitting in for Chair Lady Rudder for a few minutes, and then I'll be running across the hall. So we'll get started. Madam Clerk, if you would open the board to take roll. All right, Madam Clerk, if you would take the roll.
Mr. Chair, you have 4 members present. You have a quorum.
Thank you. First off, I'd like to ask if there's any personal orders by the members. Yes, Representative Salinas.
Hi, I would like to welcome the women of Sigma Gamma Rho to this committee. They're in their blue and yellow. Welcome.
Thank you. Glad you're here. All right. Next, we're going to do a little bit of housekeeping. Okay. Okay, we're going to start off with HB 2549. This will be rolled 1 week. Item number 4, House Bill 1910 has been taken off notice. Item number 9, House Bill 1831 has been taken off notice. Item number 11, House Bill 1485 has also been taken off notice. And item number 15, House Bill 2476 has been rolled 1 week. All right, and that brings us, I guess, to our calendar.
Chairman Rudy's here for number 2.
Okay. We don't have somebody presenting on number 1 yet. 1642, I'm sorry.
Oh, no. This is,
Yeah, okay, okay. Okay, we'll move to item,
not in yet.
pardon?
Chairman Farmer's not.
Okay,
here,
okay.
we can pick up 2.
Don't see the sponsor on item number 1. We will move to item number 2 on the calendar. And we have a motion. Do we have a second? This is on House Bill 2548. We have a motion and a second. And we do have a motion and a second. So Representative Reedy, you don't have any amendments, do you?
No, sir, no amendments.
Okay, all right. You're recognized on your bill.
Thank you, Mr. Chairman and committee. Members, you may well remember over the years I have been working on legislation to protect the sovereignty of Tennessee as also well the citizens of the United States from our foreign adversaries. This particular bill is coming from the administration to finally finish that out and with some key points that I had missed. Critical Infrastructure Protection Act and Protection of State Land from Foreign Adversaries Act will be the name of this bill. It codifies existing state policies and practices in 2 key areas. Number 1, protecting critical infrastructure does not allow the state to procure finished technology products from companies that are owned or controlled by foreign adversaries. If you recall, after the flood of Humphreys County, at that time I worked with TEMA to get the funds necessary to buy a couple drones, and those drones could not be manufactured in China, but the use of them anytime a disaster takes place with the help of TEMA, they could go into these areas that it's not safe by foot. And that's just one example. By limiting them to finished goods only, this bill will not disrupt the supply chain for non-adversarial companies. This aligns Tennessee with federal restrictions that have been in place since 2019. It allows flexibility through a CPO waiver if there is no reasonable alternative. It includes a safe harbor provision for third-party vendors that certify federal compliance. Part 2 of this, protecting state lands, prohibits state agencies from selling, leasing, or transferring any interest in state-owned real property to foreign adversaries or any organizations owned by them. Tennessee already bars foreign adversaries from purchasing private real property under existing Tennessee Code annotated 66-2-302. This closes the gap for state land. Any non-compliant transfer is considered void from inception, gives the Attorney General the power to investigate and enforce civil penalties of up to $250,000 or twice the transactional value. With that, Mr. Chairman, I stand
Thank you.
for questions.
Members, you've heard the explanation. Is there any questions? Yes, Representative Salinas.
I thought there was already a bill that we passed that didn't allow for purchasing from foreign adversaries. Do I have that wrong?
Representative Reed.
Yes, Representative, that is correct, but it never did cover state land, and that's what this is, specific for state land and the transfer thereof.
Okay. All right. Okay. I'm sorry. Okay. You're recognized.
Okay, and then for the portion of state land, do we have state land that has been sold currently to foreign adversaries? Because you said that part is not included in current statute.
Representative Reed.
Not to my knowledge, but that's where it was part of the state law that I never thought about. And of course, this is an administration bill, and that's where they were looking at it at this. You've got two departments, or the Secretary of State registration of property would be commercial or residential, but if it's farm or forest land, it had to be registered with the Department of Agriculture. But with that, and that's current state law, that if any foreign entity comes in, and then we make sure they're not an adversary of the United States. So that's covered, but once again, it's going back to state land that we need to pay attention who we're selling that off to as well. I don't know if that helps, but.
No. All right. All right. No. All right. Representative Warner.
Thank you, Mr. Chairman. I move previous question.
Previous question has been called. Without objection, we'll open the voting board for voting. Has every member voted? Anyone wishing to change their vote? Madam Clerk, if you would, take the vote.
Mr. Chair, you have 3 ayes and 1 no.
Representative Reedy, you move on out to full state and local. Thank you. We're going to move back to item number 1. I see Chairman Farmer back here. And oh, yeah. We have a motion. We have a second. And if you will indulge us just a moment, I'm going to go out of session and allow the chair lady to take back over, and I've got to run across the hall.
There you go. It's that time of the year.
All right, we're out of session. Tea.
So now we'll start over. Here, we do have a motion and a second, and you're recognized to explain your bill.
Thank you, Madam Chair, members. This bill is brought to me by the Department of Safety and Homeland Security. What it does, it removes certain expiration dates to the Tennessee Public Records Act. It preserves. We got some exceptions that have expiration dates on them that would be exempt from the Public Records Act, and what we want to do is remove these expiration dates to allow these things to move forward and stay in place. For example, records of a minor student attending an institution of a secondary or elementary education that is created by a school, resource, or other law enforcement officer will remain confidential. So there's certain things we want to keep confidential. A lot of it has to do with minors and personal information. So we need to keep these exceptions in place. There's 5 of them. I can go through them all if you want me to. If not, I'm going to be quiet. Ask for a vote.
Well, we'll just see if you need to stay quiet.
Okay.
We'll just see if we have any questions. Representative Salinas.
Can you go through them, please?
There you go.
I'll go through. I went through the first one already. Second would be persons who are required to provide personally identifiable information on crash reports, such as their name, address, and phone number, are not subject to public records. Data captured by automatic license plate readers, such as GPS coordinates, date and time information, photographs, and license plate numbers will remain confidential, not open for inspection by members of the public. The information of any federal law enforcement agent or officer conducting an operation in this state in the hands of government entity will remain confidential. So, and also law enforcement body camera that depicts minors in schools or other childcare locations, video inside healthcare institutions, and video inside private homes that aren't crime scenes will remain confidential. So those are the 5.
You're recognized.
For the information for law enforcement, isn't that already in statute?
I think certain portions are, with regards to minors, we know that even, I practice law, so I can't obtain any video body cam of an officer that even has a minor in it without a certain court order under seal. So yeah, certain parts are, but some things aren't. But regardless, we just want to be sure that sensitive information remains confidential.
No more. Anyone else have any questions for our sponsor? If not, we're ready to vote. So Madam Clerk, would you open the board for voting?
That's it.
Has every member voted? Does any member want to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 3 ayes and 1 no.
The ayes have it, and your bill moves on to the full committee.
So that's going to take us to number 5.
Okay. That takes us to item number 5, which is House Bill 1300 by Representative Todd.
Motion.
We have a motion and a second. There is an amendment filed on this bill. So Representative, would you please give us your drafting code?
It is 14644.
Motion on amendment.
14644. Yes, sir. We have a motion and a second. If there's no objections, we'll go ahead and put this amendment on the bill before us. All in favor, please signify by saying aye. Aye. Opposed, no. So the amendment goes on the bill.
Thank
And
you,
you're
Madam.
recognized to explain your bill.
Thank you, Madam Chair. The bill is a lot shorter than the explanation, I will say. Following the disruptive sleep interruptions of time this past weekend, most of you have likely received constituent complaints, just as I have. Every year for a couple of weeks in the spring and in the fall, I hear requests and demands for us to do something to stop changing our clocks. This bill does just that. A few facts about daylight savings time. It was not created for farmers. Matter of fact, they largely opposed it. Every time it was implemented in the 1900s. The first national daylight savings time law was in 1918, and it was mainly about wartime energy conservation. Matter of fact, they called it wartime. Congress repealed it in 1919 after public backlash. It returned in World War II, again to save energy for the war effort, but was allowed to expire near the end of the war. It is worth noting that the agricultural groups often lobbied against daylight savings time extensions throughout the 20th century. In 1966, the federal government standardized daylight savings times under the Uniform Time Act. It standardized start and end dates for daylight savings time nationwide, and it allowed states to opt out entirely if they stayed on standard time year-round. Those are the only 2 choices under federal law that a state has today. They can either continue flip-flopping our clocks and throwing a wrench in the biological clock of our citizens, or stay on standard time year-round. Most of your constituents notice the effects of changing our clocks, and numerous studies recognize the increased number of heart attacks, strokes, traffic accidents, and even workplace injuries and errors the week following the spring time change. Organizations such as the American Academy of Sleep Medicine and the Society for Research on Biological Rhythms have recommended permanent standard time because it aligns solar noon more closely with our biological circadian rhythms. Morning sunlight also helps regulate melatonin suppression and wake cycles. They indicate daylight savings time creates permanent social jet lag if kept year-round. This bill simply does one thing that we as state legislators are allowed to do under federal law regarding time, and that is to remain on standard time all year. This would be what we had last Saturday before the clocks changed, with naturally increasing daylight hours throughout the summer solstice. We're obviously not adding or taking away any daylight hours that we experience. We're just leaving our clocks alone year-round. I hope you can support this bill and provide relief for most of your constituents, and that is to stop flip-flopping our clocks. I appreciate your consideration.
Do we have any questions? Representative Salinas?
So our standard time, is it like what we are in now or what we were like last week? Which one would be kept?
You're recognized.
What we were in last week was standard time. We are on now on daylight savings time. So at noon on your clock, the sun will be at about an 11 o'clock position roughly. That's the reference to solar noon.
You're recognized.
I've followed some of the research that you mentioned on circadian rhythms, and there's some really cool research out of the University of, I think it's Santa Barbara, but it's crazy how something so simple that you would think is insignificant can have so many biological effects on our bodies. How many, I would have never thought that you would get these drastic shifts in the biology of people with such minute changes. So I'm in support of your bill. I think we should have done it a long time ago, frankly. So thank you.
You're recognized.
Thank you. And you know, it's almost universal. People want to stop changing clocks, almost. But you'll have some on both sides. Daylight savings time, they want more time in the afternoon so they can get 18 holes of golf in after work or whatever the case may be. You know, days are still longer in the summertime. It'll be, you know, in West Tennessee, it's going to be 7:45 before it gets dark in June, rather than 8:45. And so this is much more natural. I was quite surprised at the research too when I started digging in. I hear the complaints and I know people are feeling it, but then to find that folks have really researched this and there's a lot of data supporting staying on standard time, and then to learn how we got here, you know, was very interesting to research.
Thank you. Do we have any more questions for our sponsor? If not, are we ready to vote? Okay, Madam Clerk, please open the board for voting. All those in favor, please signify by saying aye. Those opposed, no. Has everybody voted? Does anybody want to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 5 ayes and 0 noes.
Looks like your bill's moving on to full committee. Next up, we have item number 6, which is House Bill 2610 by Representative Halsey. We have a motion and a second, and there are no amendments filed. And so, Representative Halsey, you're recognized to explain your bill.
Thank you, Madam Chairman, and it is so nice to be back in front of your committee.
I am so glad you're here.
This same bill came around before, and I'll just go ahead and admit to you, I'm flagged on it, the big flagger, but I'm starting to wear that as a badge of honor, actually. But this is going to be the last time you're going to have to hear it from me.
Well,
so,
and that doesn't make any of us up here happy. We love having you in this committee.
You've been very patient with me, and I appreciate this. Is a bill about nullification. When I tell particularly law school boys that the founders believed that the Constitution was the supreme law of the land, but not necessarily everything that Congress came out with or every law that Congress came out with or even Supreme Court decisions were not the supreme law of the land, law school boys will look at me like a Georgia redneck staring at a closed Waffle House, almost like that. And that's not the case at all when you go read what they said. Article 1, Section 1 of the Tennessee Constitution says all powers inherent in the people. that all powers inherent in the people and all governments are founded, or free governments are founded on their authority and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefensible right to alter, reform, or abolish the government in such a manner as they may think proper. Now, isn't that interesting in our Constitution that says that to not resist tyranny in government is slavish and foolish, and yet say that the federal government is sovereign over state government. And that's what we've been taught for about the last 150 years. But that's not what the old boys thought. You know, they believed in separation of powers, and that's why they put it in the Constitution of the United States. By the way, the Constitution of the United States is the supreme law of the land. But we forget the second sentence that comes after it, and it says, and laws passed by Congress that are pursuant to it. That ain't the problem. When Congress passes a law that lines up with the Constitution, that is the supreme law of the land. What do you do when Congress passes a law or an executive order comes out of the executive branch of government that is not constitutional? That's the problem. How's a state deal with that? Well, you take executive orders. There's a lot of confusion on that. Back when we had COVID, I got kind of crossways with the executive branch. And I said, you don't have a right to make law. And I was told by folks down here, just like me, other state reps, and they said, oh, yeah. The executive branch got the power to do that because we gave it to them. In the Emergency Preparedness Act, we passed back in 2001, and I said, then that's unconstitutional because the state legislature does not have the authority constitutionally to give lawmaking power to somebody else. You don't have that. So executive branch can put out executive orders, but it's only supposed to be for the executive branch. So even when the president of the United States comes out with an executive order and he passes it out, if it's just to the executive branch like it's supposed to be, that's constitutional. He can do that. If you try to make it apply to people, then it's law, and the executive branch does not have the constitutional authority to make law. So that's why in this House, back in COVID, when Biden came out with an executive order that said all employees in the state of Tennessee or employers are going to make people take a shot they don't want. 67 of you signed this resolution that the Speaker of the House and the Lieutenant Governor put out saying, no, if you try to do that, we will nullify that in the state of Tennessee. Now, isn't that interesting? Let me show you what the old founders believed. This came out in Marbury versus Madison. This is a Supreme Court decision, 1803. It says, a law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution of the United States cannot become a law. The Constitution supersedes all other laws, and the individual's rights shall be liberally enforced in favor of him, the clearly intended and expressly designated beneficiary. In the ex parte order in Siebold, and this was in 1879, it says an unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be used in a legal cause of imprisonment. In Norton versus Shelby County in 1886, an unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed. Miranda versus Arizona. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. You remember the Sedition Act? Where Congress passed a law that said you can't say bad things about the president and you can't say bad things about Congress. Oh, they blew up. That's when Thomas Jefferson wrote the resolution for the state of Kentucky and Madison wrote the one for Virginia. Thomas Jefferson says in the Kentucky resolution, whensoever the federal government assumes undelegated power, its acts are unauthoritative, void, and of no force. He added, where powers are assumed which have not been delegated, a nullification of the act is the remedy. And hence comes my bill. There's a whole lot more I can show you, but I'm not going to burden you down with it. My bill does not make the legislature nullify anything. My bill just says, if you're going to nullify, and I believe you got a right to, when Congress steps outside its boundaries. By the way, I got to say this. I have to say this. You do understand how the federal government got started. We didn't call it the federal government, we called it central government. The states got together and said, there's a bunch of onerous junk here that we don't like dealing with. We need to form a central government to take care of this. Stuff like, it's kind of hard for Tennessee to have a Navy. That's a little difficult. So things like tariffs and things like paper money, printing paper money, and things like postal roads going across state lines to other posts, there were onerous things. So the states got together and said, let's form a central government to take care of this bad stuff. Then they said in the Constitution, we're going to limit what you can do. It's in Article 1, Section 8 of the United States Constitution on what the federal government was given a right to do. Guess how many things there are? 18. 18 things that the states gave the federal government the right to do. It's like the state said, this is your little garden right here. You can hoe in this. But as far as I can see out here, that belongs to the states. You stay out of it. That played really good till about 150 years ago, and the federal government began to encroach on all these states' businesses. That's why you have the 10th Amendment to the Constitution, by the way, that says, what's not enumerated? Is that past my 3 minutes? What's not enumerated?
You're 5 minutes. You're past your 5 minutes.
Okay, I'm past my 5 minutes. I'm going to shut up. I promise I'm going to shut up.
I'm going to have to ask you to.
This is my last chance to sell it. That's how it got started. They've stepped out of their lanes many, many, many times. This bill just says there's 5 ways to deal with that. It doesn't force nullification. It just says if you're going to do it, the governor can do it on an executive issue that he really feels in his conscience is unconstitutional. A seated judge can do it if he runs across something that he believes in his heart is unconstitutional. Any legislator can do it. Or 10 communities or city governments and county governments, any combination of 10 of them can submit a letter to the Speaker of the House and he will assign it. Or 2,000 registered voters can sign a petition and send it to him and he'll assign it. And it doesn't make you do it, but it marries you right up to the people of the state of Tennessee that can ask you to do it. That's the bill.
As always, we appreciate you so much for that history lesson, and I'm very sincere about that. Thank you. Thank you so much. I think I'm going to recognize Chairman Eldridge.
I just have one thing to say, Representative Halsey. We are going to miss your presentations. They're always lively and you have a wealth of knowledge that we're all going to miss.
I'm going to miss being here ragging you.
Yeah.
Do we have any more questions? Yes, we do. Representative Selena?
I don't think I've been in committees that you had to present in front of, but I love someone that can provide the historical context and a history lesson at the same time. So I'm glad I got to be part of this as you're going to. My question is, so this is in dealing with the federal government, not like the state government, right?
Right, that's correct.
Okay, just making sure I understand.
That's right.
Do we have any more questions for our sponsor? If not, we're ready to vote. Madam Clerk, please open the board for voting. Has every member voted? Does anybody wish to change their vote?
Thank you,
not-
committee and chairman,
If
chair
not,
lady.
please take the vote. Clerk, please
Thank you.
take the vote.
Madam Chair, you have 4 ayes and 1 present not voting.
The ayes have it, and your bill moves on to full committee. You just assumed that, didn't you? You just walking out of here thinking we were going to just pass your bill? Up next, we have item number 7, which is House Bill 2010 by Chair Lady Littleton.
Motion.
We have a motion and a second, and you do have an amendment. Can you give me that drafting code? But
I just want to say a few things first.
You go right
I
ahead.
hate to follow that. I'm going to be short and sweet, but we hit a nasty little snag yesterday afternoon that we're trying to work on. Some of those little surprises that come along. So I need to roll this a week if possible.
That is, yeah, you're going to roll the bill for a week.
Mhm.
So
we're gonna
House
work on it.
Bill 2010 is rolled for one.
Thank you so
We'll
much.
see you back here next week. Yes, I know. I know.
Item number 8.
Next up, we have item number 8, which is House Bill 1890 by Representative Himmer. We have a motion and a second, and there are 2 amendments filed on this bill. So, Representative, would you give me your drafting codes?
Yes, Madam. Last week we had an amendment that put on, I'm not sure exactly posture, but based on some testimony and work we did with the department, we have a new amendment that will redraft the bill that would like to run, and that drafting code is 014863.
So 014863 is the one you want us to put on the bill.
Yes.
Okay, we have a motion and a second. If there's no objections, we'll go ahead and get the amendment properly before. So all in favor, please say aye. Aye. Those opposed? The ayes have it, and the amendment goes on the bill, and you're recognized to explain your bill.
Thank you, Madam Chair. Members of the committee, if you remember from last week, we had a conversation about this bill's dealing with the Department of Education and allowing members to request certain information and have kind of a similar process of what we have for DCS, where we're able to go and look at records within the department. The Department of Education had a couple of items they requested to remove from the bill around school safety. So it's school safety plans, school building diagrams, employee records are otherwise confidential pursuant to federal law. So it was able to work with the department and get this included in the amendment. And from my conversations with them, they're now defer.
Okay, we do. Do we have any questions for our sponsor? If not, we're ready to vote. Please open the board for voting. All those in favor, please vote aye. Those opposed, no. Has everyone voted? Does anyone wish to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 5 ayes and 0 noes.
Your bill, the ayes have it, and your bill moves on to full committee. Next up, we have item number 10, which is House Bill 2462 by Representative Pearson. I don't see him, so we'll just go ahead and move this House Bill 2462 to the Hill. Next up is item number 12, which is House Bill 1906 by Representative Scarborough. We have a motion and a second. There is an amendment filed on the bills. Would you give us your drafting code?
013438, Madam Chair.
Yes. Do we have a motion and a second on this amendment? There's no objections. We'll go ahead and put that amendment on this bill and get it properly before us. All in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment's on your bill, and please explain your bill to us.
This bill simply creates legislation that allows members subject to mandatory retirement to receive retirement credit for periods of disability at no cost to the member. Members subject to mandatory retirement employed by the political subdivision may be granted retirement credit at the cost to the member, at no cost to the member. The political subdivision adopts the corresponding plan provision. Now, this, by the way, is TCRS members. I want to make that clear. The objectives under this current law is a member is required to take a lump sum payment of the employee contribution that would normally have been made during the absence plus interest. Allows the following to establish retirement credit for qualifying periods of temporary disability without financial cost to the member. And those members are Safety and Highway Patrol, Department of Safety and Highway Patrol, TBI, TWRA, and the Alcoholic Beverage Commission. Members who are subject to mandatory retirement must submit an application to the retirement system on or after July 1 of 2026 to establish retirement credit for disability periods. Authorize political subdivisions to adopt resolution to establish retirement credits for qualifying periods of temporary disability for members subject to mandatory retirement at no cost to the members. No member shall be granted retirement credit in excess of 1 year per occurrence of a temporary disability. And with that, I kindly ask for your approval.
Do we have any questions for our sponsor? Representative Salinas?
I'm not too familiar with the term mandatory retirement. Can you describe that and kind of give examples of scenarios that would be considered a mandatory retirement?
You're recognized.
While not specified in the bill, I would assume this is mandatory age requirement.
So that's just a function.
You're recognized.
Sorry.
Got to get your mic on.
That's just a function of age. Is that what you're saying?
You're recognized.
I believe that's correct, ma'am.
Any more questions? Are we ready to vote? Madam Clerk, please open the vote. All of those in favor of this bill moving to full committee, please signify by saying aye. Voting yes. Opposed, no. Has every member voted? Does any member wish to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 5 ayes and 0 noes.
The ayes have it. Your bill moves on to full committee.
Thank you, Madam Chair.
Oh, number 13. I don't have. Okay, this is item number 13, and this is House Bill 1870. We have a motion and a second, and I do believe you have an amendment. Could you give us that code?
015418.
04, okay. Let's go ahead and, do we have a motion and a second? Did I hear that? Motion and a second on the amendment. If there's no objections, we'll go ahead and put this on the bill and get it properly before us. All those in favor, please signify by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is now on the bill, and you're recognized to explain the bill.
And the amendment simply just to change the effective date of passage from January 1 of 27 to January 1 of 28. The reason for this bill is to create a standard of training requirements for fire investigators that are acting as police officers. Clarifies police powers for fire investigators, ensures consistency with other law enforcement agencies, creates statewide consistency, standardized requirements, clear statutory authority, strengthens criminal case credibility, and reduces the legal challenges with arrest authority. And with that, I'll stand by for questions and kindly ask for your approval.
Do we have any questions? If not, we're ready to vote. Madam Clerk, please open the vote. All in favor, please signify by saying aye. Opposed, no. Has everybody voted? Does anybody wish to change their vote? If not, Madam Clerk, please take the vote.
Madam Chair, you have 4 ayes and 1 present not voting.
The ayes have it, and your bill moves on to full committee. You're welcome. Next up, we have item number 14, which is House Bill 2098 by Representative Warner. We have a motion and a second. Is there an amendment filed?
Yes.
There is an amendment filed. So Representative, would you give us that drafting code?
Yes, ma'am. Thank you, Madam Chair. I have 013203.
Okay, with that, if no one objects, we'll go. Oh, and we got a motion and a second on that. Okay. If no one objects, we'll go ahead and put this on the bill and get it in the proper position. All in favor, please signify by saying aye. Aye. Opposed? No. Ayes have it. The amendments on the bill, and you're recognized to explain your bill.
Thank you, Madam Chair and Committee. Today, I'd like to introduce to you House Bill 2098 for passage. Committee, this legislation is to promote public integrity in the state of Tennessee. This bill requires a state employee who has knowledge that another state employee has engaged in improper governmental conduct or criminal activity to report the matter to a supervisor. The supervisor is then required to report the conduct to the Attorney General. And if the conduct is criminal, which would include bribery, contraband in our correctional institutions, perjury, official misconduct, official oppression, and the misuse of public office, it shall also be reported to the appropriate law enforcement agency. Improper government conduct includes conflict of interest prohibited by law, gross mismanagement, or gross waste of public funds, and the abuse of authority or substantial and specific danger to the public. After the supervisor has determined that there is a reasonable cause to believe that the conduct occurred, the supervisor is required to report the conduct to the Office of the Attorney General, and if criminal, to the proper law enforcement agency. No retaliatory action may be taken against the reporting employee. If the supervisor intentionally fails to make the report or turn over the file, it's a Class B misdemeanor. Excuse me here. This bill is intended to bring more accountability and more transparency in the operation of state government. The state of Tennessee has 42,000 employees. It's safe to assume that some are good employees and some may not be. If a good employee has knowledge or knows facts that an employee has violated the law, they may feel intimidated or believe they could face retaliation. This step gets another set of eyes on what has happened without the threat of retaliation. This law passed in the state of South Dakota in 2024, and in 2025, the state attorney general announced 47 unique arrests of employees in the state of South Dakota. Now, Madam Chair, yeah, I'm not done yet. I want us to pay close attention right here, committee, and the people watching at home. This is some serious stuff right here. What the Attorney General uncovered in South Dakota. I'm going to give four things here. A social worker who worked in Child Protective Services was arrested and fired for falsifying information in a child protection investigation. A corrections officer was indicted for smuggling contraband into the prison. A university equestrian coach was indicted for using state resources for personal use. An employee at the Department of Public Safety, now listen to this one right here. An employee at the Department of Safety was indicted with 85 counts of using his state computer to distribute child pornography. This happened in South Dakota. And the solicitation of sex with a minor. Tennessee is not without its own challenges. This bill will give honest state workers who see wrongdoing by others in the department an opportunity to report without fear of retaliation and compel the supervisors to engage the Attorney General or law enforcement and to ensure that this investigation is completed and appropriate action is taken. I'm going to skip over a little bit to try to save a little time here. And with that, Madam Chair, I move approval on this bill. And I think we have some testimony here.
We'll go out of session and we will listen to our testimony. And I believe it's Miss Connie Ragugli. We're out of session. You have, please state your name and who you're with, and you have 3 minutes.
I have a national grassroots organization called the Family Forward Project that is about 29,000 families across the U.S. I currently reside in Rutherford County. I also have properties in Williamson County, Grundy County, DeKalb counties. As an attorney in Tennessee for 3 decades, I traveled across the state of Tennessee and appeared in courtrooms in at least half of our counties, often defending parents against some of the corrupt practices of the Department of Children's Services and other state agencies. As an attorney, I have dozens of reported cases at the Court of Appeals, the Sixth Circuit Court, and even the Tennessee Supreme Court. The pressure I put on state agencies was too much. In 2018, an employee of the Department of Children's Services made false statements in a sworn petition claiming that my client and I had refused to cooperate with the Department of Children's Services, even after I'd made multiple phone calls agreeing to cooperate with the agency. Instead of returning a phone call, they made a false statement in a court petition and got a removal order, which caused my client's child emotional injury forever. In the course of those events, in 10 months, my clients and I were ultimately arrested on a fake crime at the insistence of DCS. In those criminal proceedings, the DCS state employee again made false statements under oath and committed aggravated perjury. All due to the fabrications made up by state employees, my client and I were convicted of fake crimes, which ultimately were reversed. In the meantime, I filed agency and police reports on the corrupt activities, the perjury, the false statements, the making up of fake crime. They well knew it within the agency what had occurred, and nobody was reprimanded, nobody was arrested. This bill is a better step towards public integrity in the state of Tennessee. South Dakota passed this bill and has already taken measures to remove those from state agency that commit crimes and violate other duties that the taxpayers paid for. In my case, the taxpayers of Tennessee spent thousands of dollars prosecuting me and my client for fake crimes. You know, with respect for the committee, you are a small contingency of Tennessee constituents. And here on this bill, we have not only Representative Warner, but we have already added 8 additional co-sponsors, which I have worked really hard to acquire along with Representative Warner. So I would just ask that you pass this bill out of subcommittee, and I'm open for any other questions.
Do we have any questions for our guests? Yes, Representative Salinas.
Thank you for all of that information. In South Dakota, did they see any increase in reporting once the bill was passed? And what kind of information came out of that? If you know, I know it's a different state, but can you just kind of speak to that?
You're recognized.
All right, thank you. Yes, and that bill actually passed in 2025, and within 6 months, they had 47 unique complaints of different activities and criminal activity that had happened among state employees. There is they have online actually a public integrity report that was created by the South Dakota Attorney General. And just to say, another reason the Attorney General is important is because the Attorney General in the state of Tennessee has the power of ouster. They're really the only ones, even though the statute says 10 people can bring ouster, really only the Attorney General does that. Whenever you have a state official who has committed corrupt activities, the Attorney General has to have that from somewhere. So we have to move it out of the eyes of the agency directly and get it into the hands of the Attorney General.
We have don't have any more questions for our guests? Yes, Representative Warner.
Thank you, Madam Chair. With what's gone, and thank you for your testimony today. With we've seen gone on in the state of Minnesota, do you feel like this bill would help Tennessee to prevent maybe millions of dollars from being defrauded from the state, or maybe uncover some stuff in the state that's currently going on?
You're recognized.
Yes, it's South Dakota representative, not Minnesota. Oh, with Minnesota, the events in Minnesota. Oh, yes. So in this bill, we do say that those nonprofits and contractors that are doing a state function would be part of this process. And that's what we had. And that's another reason I worked with Representative Warner to add that to the bill, because in the state of Wisconsin, they had, or Minnesota, whichever one it was that did all of that corruption with the health care benefits, but it certainly would apply to that. I also work with a lot of whistleblowers throughout this state. I really don't have time to share that with you, in the Department of TennCare and certain law enforcement agencies with DCS. So I know there is the opportunity for us to begin to just sort of provide better services to the state of Tennessee in the long run. Thank you.
Yes, Chairman Eldridge.
I'm going off of what Representative Salinas asked about. Was there an increase? I know you said there was 47 unique cases. How many were there before this law was enacted? Was it, and I guess my next question is, I know that the comptroller's office goes through and looks at a lot of situations like this. And I know of some of them in my area. I mean, they don't go unnoticed. And my concern with the bill is, and I don't know if everything is that you're trying to cover is not already covered somewhere. I mean, you said you had so many cases that you deal with whistleblowers. They're already talking. And I was wondering if the state has don't they have like a hotline where you can anonymously turn in a situation where you think there's fraud going on or abuse of the system? I'm thinking there are. I don't know if legal has information on that or not, but that's just some of my concerns here.
Yes, I would like for you, legal, to respond since we're out of session.
Thank you, Matt Mundy from Legal. There may be one. I'm not aware of a statewide hotline. I think what the current circumstances are is that it's permissive to report to your supervisor if you notice any conduct that's unbecoming or dereliction of duty, or that's may even rise to being a crime. This bill is seeking to mandate that report rather than just permissively letting a employee go to a supervisor and report that conduct.
You have a question? Okay. Representative Warner, you're recognized.
Thank you, Madam Chair. So if I understood you right, right now it's permissive. So let's say if an employee of the state went to a supervisor and reported misuse of funds, misconduct, whatever we want to call it, it would be up to that supervisor to either say, hey, yeah, I'm going to move this forward, or sweep it under the rug. Is that a fair statement?
Thank you, Matt Mundy, for the record. I think it would probably also depend on the personnel policy of various agencies of the state. I can't speak to each one of them. They certainly all have theirs. We have one here for the legislature, and even a different one for our office. So there may be personnel policies that require the reporting of certain information. But as far as what's in the code, I don't believe that there's a mandate to report those types of activities.
Do we have any more questions for our, for legal or for our sponsor? I mean, the guest, I'm sorry. You have a question for your guest? Okay, go ahead, Chairman.
Not so much a question as a comment.
Okay.
And this happened in my area. We had a trustee that was kind of moving some money around, and one of the employees there knew about it. She made the decision to contact the comptroller's office, which I'm looking at right here on Representative Langford's screen, the fraud, waste, and abuse. And there was an investigation, there was a trial, there was a conviction. So I kind of feel like, and then I know that, in this bill, the one really troubling thing is it's making it a misdemeanor if they don't. I mean, they're making a tough decision already, but you're gonna criminalize them. And I'm not particularly crazy about that. But that's just my comments, because and I've had enough, I came out of county government. I know, that what happens there. I know when you're dealing with people, maybe it's a serious problem in some big cities or something like that, or bigger counties than what I represent. But I know of current investigations that the comptroller's office is doing in my area. So I thank you for the bill. I know the intent is well, but I cannot support it.
I would also like to add to that and concur with my colleague. I'm also from county government, and I do know the reporting mechanisms there and how people are held accountable. But I do have a real problem with a supervisor being held on criminal charges. So that's my problem with the bill, and I just want that on the record. Do we have any more questions? We're ready to go back into session. You did have it. We're not going to have any more testimony. Do you
Order, Madam Chair.
recognize?
I think we had another testifier that filled out the witness card.
That's right, but that's at my discretion. You're also.
Again, Madam Chair.
Thank you. Did you have something to add?
To that, because
Please.
in that bill, it specifically says, and I've served as a prosecutor too, in that bill, it specifically gives the opportunity to the supervisor some discretion because it says this, if the supervisor has reasonable cause. So there certainly, it's not like a mandatory reporting. If somebody comes to you and it's some kind of rumor mill, it gives the supervisor the opportunity to take a look at it and make a decision as to whether or not there's reasonable cause. So if there is a mandatory reporting and as to your question, I did not get to respond to, this was a new move for South Dakota as well. So again, there are comptroller things, but this puts it within the agency. I know I could give you a lot of situations with the Department of Children's Services where within that agency, caseworkers have come out and said that they cannot report what has happened because they will be retaliated against.
If we have no more questions for our guests, did you have another question? Or you need to go back
Madam
into
Chair, I
session?
make a motion that we go back into session.
Session, okay. Thank you for testifying before us today. We're going back into session now. Do we have any more questions? Yes, Representative Warner.
Thank you again, Madam Chair. And again, I think I feel where the committee's leading on this, where our votes are going to wind up. This, like the lady giving the testimony here, this just gives another step, and it gives the supervisors the option to determine whether they think the conduct is criminal or not. You know, it puts another set of eyes on our taxpayers' dollars that's coming into this state. And, you know, I don't see why we wouldn't support something like this that puts another set of checks and balances in place. And that's all I got to say. And I ask your support on the bill. Thank you, Madam Chair.
Representative Salinas, you're recognized.
We deal with so many things up here that have, or our departments do, that have consequences. Department of Education, Department of DCS, Department of Disabilities. And I understand the hesitation behind criminalizing not reporting or how the bill is stated. But with everything that has happened in DCS and the length of time that it has taken to get some of this information, and we're talking about kids, right? There should be consequences to that. If you know something and you don't say something, when we're dealing with kids, when we're dealing with disabilities, when we're dealing with education, I think there should be accountability at that level. And this bill just tries to achieve that. And we do have evidence that some of this stuff has been happening, especially in the Department of DCS. And I know that we all would like to protect kids, and I think this is a way of doing that.
You're recognized.
Madam Chair, I got one last thing and I'll be done real quick. Let me ask if the committee would do this, if they would move this bill forward and let's get some of these concerns and maybe let's amend this bill further into the next committee and see if we could address maybe that part about the mandatory crime or whatnot. Let's see if we could work on that a little bit more, but maybe we still leave in the part that the reporting gets done to the Attorney General, and maybe he determines, and we take that section out of the bill. Would the committee be okay with that? If we could move this forward and get it amended before it's seen in the next committee?
Chairman Eldridge, you're recognized.
I just had a text message from CTAST that there is a statewide hotline on waste, fraud, and abuse.
Are you recognized?
Yeah. Chairman, and I appreciate your comments there, sir, but we're talking about more than just waste, fraud, and abuse here. We're talking about a lot more. And I appreciate CTAS's concern and their hotline, but we are talking about a lot more crimes than waste, fraud, and abuse. And I think if we can move this bill forward, and I think we can get it in the proper form where the committee, the next committee it would go to would be fine with it. Thank you, Madam Chair.
Yes, Chairman Eldridge.
Madam Chair, I move previous question.
Previous question's been called and we're ready to vote. All those in favor of House Bill what's the House Bill number? 2098. Oh, first of all, we're going to have to open the board, Madam Clerk. And all of those in favor, please signify by saying yes. Those opposed, no. The ayes have it. And
Recognize the clerk.
recognize the clerk. Yes, I'm so sorry. Go ahead, clerk. Open the board for the vote.
Madam Chair, you have 3 ayes and 2 noes.
The ayes have it, and your bill moves on to full committee.
Thank you, Madam Chair.
That takes us to the heel.
And that takes us to the hill of the calendar, and that is item number 10, 2462 by Representative Pearson. Is he in the room? He is not. Thank you. I have to recognize you to make a motion, so I'm going to recognize you. Now, please make the motion.
I'm still learning.
That's
I appreciate
okay.
your
That's
patience
okay.
with me. I move to roll the bill 1 week.
House Bill 2462 will be rolled for 1 week. And without objection, I think we're adjourned.